the claimant's claim on arrears of salary succeed and same is hereby granted. The dependent have strenuously argued in their address that the claimant has the burden. This is a clear misconception of the law. The reason being that the Court of Appeal in the case of Honica Sawmill Nigeria Limited versus Hope, reported in 1992 for NWLR Part 238, page 673, has given insight as to the party that has the burden of proving payment of salary. It stated as follows, I quote, as between an employer and employee, the onus is on the employee to prove that employer employed him on a split salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that he has paid employee his salaries for work done by the employee in the relevant period, but also how much salary that he paid to the employee was. Unquote. End of quote. In the case at hand, the claimant by the Exhibit A has proved his employment with the claimant, with the dependent, which the dependent did not deny, and by the Exhibit D, letter of termination of appointment has proved that the period he served the dependent, which tallies with his claim. This means that the claimant has discharged the burden of proof imposed on him by the law. The dependent, instead of adducing evidence of payment of salary, decided to stand aloof towards the proceeding with no evidence in proof. The dependent must blame themselves for this blunder, as the strategy adopted was a wrong strategy and a costly one for that. The issue of alleged contradiction cannot hold water, as a holistic perusal of the consideration of the totality of pleadings of the claimant will surely confirm that there is no contradiction. The claimant, by stating that he worked from 2012, 2013, and 2014, did not mean that he worked for the whole of these years. The exhibit tendered by the claimant read in conjunction with the pleading there. There is no difficulty in coming to the conclusion that the claim of the claimant is only for 21 months arrears of unpaid salaries, which the dependent alleged that they had paid to the claimant, but failed to support their claim with any credible evidence. The dependents have also made heavy weather on the alleged insubordination and sabotaging of the dependents by the claimant, which the dependent stated justified termination of the claimant's employment. I have had a hard look at the pleadings. And the claim of the claimant. There is nowhere issue of termination of claimant's employment with the dependent was raised. The claimant's case before the court is a claim for payment of his arrears of unpaid 21-month salaries. The claimant has never raised or put in issue termination of his employment. All the abandonment in the statement of defense regarding purported insubordination and sabotage goes to no issue, as they are not in response to any issue regarding discipline of the claimant. The termination of claimant's appointment, and the reason therefore is not and has never been an issue in this case, as parties did not join issue on the propriety or otherwise of termination of claimant's appointment. On the claim for 20 million naira general damages in employment case, once claim for salary has been granted, it will amount to double compensation to grant damages. The claim for general damages failed and same is hereby refused. However, the claimant is entitled to costs which I assess in the sum of 1 million naira. The dependents are hereby ordered to pay the sum of 1 million naira to the claimant as cost of this suit. From all I have been saying above, the claimant succeeded in improving part of his claim and is entitled to arrears of his salaries as per his claim. He is also entitled to cost. In view of the foregoing, it is hereby ordered as follows. A, the claimant is entitled to arrears of unpaid salaries for 21 months amounting to the sum of 1,260,000 naira only. The dependents are hereby ordered to pay the claimant the said sum of 1,260,000 being his unpaid 21 month salaries. The claimant is entitled to cost of 1 million naira. The dependents are hereby ordered to pay the claimant the sums of 100,000 1 million naira cost. All the judgment sums granted shall be paid within 30 days, failing which 10% interest shall apply. Judgment is entered accordingly.
The court pleases.
Not my case.
Your own is the laptop now. Open your eye. Open your eye. Don't do this. Open your eye. Rich.
Something. Cost.
Yeah, I need to ask. Mr. Nachamada. They do that matter. I know there was something good going on. Because they know they do any at the Bible.
Yes, Registrar, call the next case.
Yes, my lord. Suit number NICN TA 61-2017 between Frederick Ogbogoro and 1, Government of Cross River State. 2, Civil Service Cross River State. 3, Board of Internal Revenue, Cross River State. My lord, parties.
Yes.
The parties are all.
Please, counsel should mute their microphone until when they are to talk. Please.
Are you calling someone?
Part is not present.
Yes, my lord. Parties are all absent, my lord.
Appearance.
With utmost respect, my lord.
Yes.
IT Basi.
IT Basi.
Yes, my lord. Appears for the claimant.
For the claimant.
Yes, my lord.
Are you alone?
Yes, I'm alone, my lord.
Yes.
With due respect, my lord.
Yes.
Ama Epo.
Yes.
My appearance is for all the defendants.
Okay.
Thank you, ma'am.
This matter is for judgment. The judgment is ready and it will be read shortly.
The court pleases.
Give me your phone.
Who is this one?
This judgment is very bulky, so I don't know. I will try to see how we can manage to skip most of the things. I think we should skip the preliminaries as I have reproduced the reliefs being claimed by the defendants, well, being claimed by the claimant as per his amended complaint and statement of facts. I have also captured the case put forward by the claimant in his pleadings, witness statement on oath. I have also captured the case of the defendant, the reply to the amended statement of defense by the claimant. I have captured all those in the body of the judgment, so I will skip reading them. I have also captured the submissions of the claim of the defendants who formulated a single issue. No, twin issues, who formulated twin issues. I have captured the argument of counsel on those two issues. I have also captured the argument of the claimants, the submissions of the claimants, who also formulated two issues after adopting the first issue formulated by the defendant. He formulated his own second issue. I have captured the argument. I have also captured the reply on points of law filed by the defendants. I will go straight to the decision of the court. And it goes like this. I have carefully perused the processes filed in this suit, as well as the evidence laid by the parties in proof of their respective cases as presented to the court. I have also considered the final written addresses of parties, the reply on point of law filed by the defendants. I have equally listened attentively to oral submissions of counsel in adumbrations of their respective position. The facts that culminated into the institution of this suit have been extensively stated above. I shall start considering the issue of alleged non-signing of the two witnesses. I shall start this judgment with the issue of non-signing of witness statement on oath by the claimant himself, dated 16th day of December 2021 and that of 13th day of December 2022, respectively. In the course of cross-examination of CW1, the counsel for the defendant questioned the CW1, the claimant, regarding signing of his two witness statement on oath. Consequently, CW1 was asked to sign all the signatures on all his signatures on a plain sheet of paper, which he did sign only one signature, and it was tendered in evidence and admitted as exhibit CW1N. CW1 also stated that the signature he signed, in that signature is his signature, which is his official signature, but he has other signatures for his bank transactions, which he cannot reveal to the court. At that point, counsel for the defendant sought for an adjournment. At the resumed hearing on 13th day of December 2022, for continuation of cross-examination, counsel for the defendants put to CW1 that he has only two signatures. In response, the claimant, CW1 stated that it is not correct that he had only two signatures. He then stated that what he told the court was that he had several signatures for different purposes, and that what he knows, all processes before the court were endorsed by him. The witness was then shown a signature on the amended witness statement on oath of 16th day of December 2021. He was asked to sign the said signature since it was it was him that signed it. He signed on a sheet of paper, on a plain sheet of paper, and it was tendered in evidence, and it was marked as Exhibit CW10. The counsel for the defendant argued that asked the court to compare the signatures of the claimant, which he has signed before the court in the course of cross-examination, and the signatures on the two witnesses' statement on oath in question. Counsel asked the court to find that the claimant did not sign the two witness statement on oath by himself. Counsel also asked the court to expunge the two witness statement on oath. It was also argued that if the two witnesses statement on oath are expunged from this proceeding, there will be no evidence before the court to support the pleadings of the claimant or sustain the claim of the claimant. Counsel asked the court to hold that the claimant has failed to prove his case due to lack of evidence, as pleading without evidence goes to no issue. The counsel for the claimant, with a wave of hand, dismissed the defendant's objection to the two witnesses' statement on oath because, according to counsel, the defendants are well aware of the perceived omission or inadequacies in the two witnesses' statement on oath, and after becoming aware, took fresh steps after being served with the claimant's amended complaint and accompanying processes by filing amended statement of defense. They participated in the trial up to filing of final written addresses. Counsel submitted that the defendants cannot approbate and reprobate at the same time. Counsel also submitted that, assuming without considering that the two witnesses' statement on oath belong to a different person, CW1 having entered witness box and on both adopted the said witness statement on oath, they become his evidence and are admissible. Counsel urged the court to discountenance the submissions and give full weight to the unchallenged and uncontradicted evidence of CW1 in support of his pleading. There is no doubt witness statement on oath of a witness, when adopted by a witness after the witness had been sworn, become his evidence in the matter, to which the court can use in considering the case of the parties of the party adopting the witness statement on oath. However, I must quickly add that for adopted witness statement on oath to have any efficacy, it must have been duly executed by the parties. Furthermore, for any adopted witness statement on oath, furthermore, the evidence, the adopted witness statement on oath must be, for it to have evidential value, must be evidence of the said witness that adopted the witness statement on oath. Otherwise, it will become hearsay evidence, where there is a dispute as to whether or not a signature on a witness statement on oath is genuine or not. The party who alleges that the signature is not genuine or it is a fake signature has the onus of proving to the satisfaction of the court of the allegation concerning the said signature. See the case of Frederick versus Idigbe. The law is well settled that where a court of law is faced with disputed signature, one of the methods of proving signature is by comparing the disputed signature with the signature agreed to be undisputed or genuine signature. See the case of Tomtech Nigeria Limited versus Federal Housing Authority. See also Adele versus Wolude. In the instant case, the claimant under cross-examination stated that Exhibit CW1N is his official signature, which he signed in open court. He also told the court that his other signatures is for his banking transaction and that he cannot reveal it to court. But on 30th day of December 2022, CW1 also informed the court that when he was confronted with signature on witness statement on oath before the court and asked to sign the signature on the witness statement of oath, he then told the court that what he said was that he had several signatures. Exhibit CW1 oath was signed in open court as signature on the witness statement on oath. I have taken a critical examination of the signatures on the witness statement on oath and that of the witness statement on oath of 16th day of December 2021 and which the defendant disputed their authenticity. I am strengthened in my conclusion considering the fact that the claimant was even shown the witness statement on oath of 16th day of December 2021 in open court and asked to sign the said signature on it, which he claimed to have signed, but still could not correctly sign the said signature. I do not accept the claim of the claimant that he has several signatures, as he was given opportunity to sign all his signatures, but he signed only one, as shown on exhibit CW1N, and claims that that is his official signature, and his other signatures are for banking transaction, and he cannot reveal it to the court. If it is true that the signature on exhibit CW1N, as claimed by the claimant, is his official signature, why then has the claimant not signed that signature on his witness statement on oath? From my finding, the claimant was not truthful concerning signing of his witness statement on oath. The counsel for the claimant has also argued that the objection to signing of signature was too late to be raised at the stage it was raised. I do not subscribe to this submission. The reason being that if it was raised at the earlier time, which evidence will the court use in determining whether the witness statement on oath was signed by the claimant or not? Having found that the two witnesses' statement on oath accompanies the statement of facts and the one that accompanies the reply to the statement of defense were not actually signed by the claimant, the said witness statement on oath, the said witnesses' statement on oath lack evidential value. They are reliable. Same are hereby discountenanced for the purpose of this judgment. The discountenances of the two witnesses' statement on oath of the claimant means that there is no evidence adduced by the claimant to prove his case, as pleading alone cannot establish a case without evidence to establish the claim made as per the statement of fact. The absence of evidence to support the pleading means that the claimant has abandoned his claim for failure to lead evidence. See the case of Obiamimi versus Brick, Omiamimi Brick versus ACB. See also Union Bank of Nigeria versus Ayodare and Sons Nigeria Limited. See also Ipeta versus Shell Petroleum Development Company Nigeria Limited. See also Arabambi and another versus Advanced Beverages Nigeria Limited. See also AG Perero Company Limited versus Henken Chemicals Nigeria Limited. The disposal of this issue is enough to end this matter. However, this court being court of first instance, I shall proceed to consider merit of the case of the claimant, so that in case of appeal, the Court of Appeal will have the benefit of having the views of this court on the substantive case of the claimant. Before delving into the substantive issue, substantive case put forward by the claimant, there is another preliminary issue that need to be dealt with, and this issue was raised in paragraph 18. Paragraph 18 of the amended statement of defense of the defendant dated 13th day of April 2022, which borders on allegation that the claimant is suing wrong party. According to the defendants, by law establishing third defendant, Board of Internal Revenue is not the correct name of the third defendant, as the correct name of the third defendant is Cross River State Board of Internal Revenue. Counsel submitted in any action competence of parties, whether plaintiffs or defendant, is very vital and important as it goes to the foundation of the suit and constantly touch on jurisdiction of the trial or appellate court. In support of this submission, counsel relied on the case of Akindele versus Abiodun. Counsel also submitted that an action can only succeed if the parties to it are shown to be proper parties to whom right and obligation arising from the cause of action attached. Parties are those who have direct interest in the subject matter of the dispute. That is, there must be a nexus between the plaintiff and the defendant or the appellant and the respondent. Therefore, for a court to be competent and have jurisdiction over a matter, it is necessary that the condition that the proper parties must be identified is fulfilled. It is submitted that the implication of not signing of not suing the third defendant in its proper name amount to suing a wrong party. The implication is that if there is judgment, it will be difficult to enforce. The claimant in reply submitted that the argument of the defendant on suing wrong party is misplaced because since becoming to be aware of the error, they have been filing processes and taking part in the trial to the very end without raising any issue about the name. The act of the defendants keeping quiet when they notice this error of the name of the third defendant instead of raising preliminary objection immediately amount to a waiver on part of the defendant. Since the counsel on this submission relied on Kipau versus Kipau in the estimation of the defendant. This court lacks jurisdiction to entertain this suit because the third defendant is wrongly sued. That is to say, is a non-juristic personality, as by virtue of Section 1 of the Revenue Administration Law Number 9 of 2011, the organ created with the personality is Cross River State Board of Internal Revenue. The general rule is that only juristic persons, whether natural or artificial, may sue or be sued a nominee. See the case of Gani Paweme versus MBA number 2. See also Reverend Rufus Omenkwesi versus Registered Trustees of Methodist Zion Church. See also the case of Executive Chairman Management Benue Sobe versus Nasu. It is clear naming a juristic person as a party is not a mere misdescription or misnomer in a case, and there cannot be a valid amendment to the title of a suit where the person sued was never a legal person. See the case of Okechuku and Sons versus Inda, 1967, Nigerian Muslim Law Report, page 368. See also Inzom versus Jinadu. The only option open to a court that find in such a situation is strike out the name of the non-juristic person and terminate the suit if there is no other competent claimant or defendant on the record. See Agbama Bay Bank Limited versus General Manager Olibant. See also Gani Paweme MBA versus MBA number 2 Supra. See also Village Usopia versus Umeze Village Union and others. See also Idare Local Government versus Government of Ondo State. However, it is not the law that where an entity close with legal personality is misdescribed or wrongly designated, as in this case, such an entity loses its judicial personality or metamorphoses into a non-judicial entity. In Agbamobe Bank Limited versus General Manager Oliban, what the Supreme Court decided is that the title General Manager GB Oliban is not a description of a jurisdiction or of a juristic personality. Therefore, the defendant so named was struck out of the action, but designating a juristic person otherwise than its correct corporate name is often treated as a misnomer that will not vitiate proceeding. Such wrong designation or misdescription can correctly by an amendment, or it can be corrected by an amendment, or even on appeal, as was done by the Supreme Court in the case of Ode and others versus the Registered Trustees of Diocese of Ibadan. The point to note is that it is not the designation by which the party sues or is sued in an action that determines whether the party is a judicial entity or not. Rather, it is the function of the due registration and or recognition under the extant laws. Therefore, it is erroneous to assume that the Board of Internal Revenue, Cross River State, was a reference to a non-judicial person, simply because the word Cross River State was stated to be the last words in the name instead of beginning with those words. The way of naming the third dependent is a mere misnomer or description in this case that does not infer the competence of this proceeding or the jurisdiction of the court to entertain this matter. Misnomer simply means a wrong use of name or a mistake in naming a person. In naming a person, place, or things, especially in a legal instrument. See Black's Law Dictionary S edition, page 1021. Where there is a misnomer or misdescription in the title or caption of any proceeding, what the court will consider in order to nullify such proceeding is whether the misdescription in the title has substantially misled the parties, or whether a miscarriage of justice was thereby occasioned. See the case of Bayo versus Njida. See also Ajad versus Ajibola, and the case, see also Bajoga versus Government of Federal Republic of Nigeria. In the context of litigation, misnomer occurs where the entity suing or intended to be sued, but a wrong name is used to describe that entity, as it was done in this case. See Max Line versus Adide Investment Limited. So where a correct person was brought to court under a wrong name, a misnomer has occurred. See also a MESPO J Continental Limited versus Quorum S. Imba and Company. Having regard to the foregoing, it seems to me obvious that there is no doubt the third dependent was the entity sued in this case, but that the name was merely misdescribed or wrongly stated. Therefore, the designation of Board of Inland Revenue was a misnomer that is not capable of vitiating the proceedings before the court or hosting the jurisdiction of the court to determine the matter. The defendants are just trying to make a mountain out a molehill. In view of the finding, the objection by the third defendant lacks merit and same is hereby refused. Coming to the substantive suit, the case of the claimant, as can be gathered from the pleadings, witness statement of oath, and the exhibit tendered in the course of this trial, is to the effect that the first defendant engaged a firm of consultant, H. Pearson Associates Limited, to carry out executive recruitment exercise to fill vacancies to revenue service in the revenue service of the first defendant. In furtherance of this, an advertisement was placed by H. Pearson Associates Limited in the Guardian newspaper publication of 28th day of June 2011 at page 9, calling for qualified candidates interested in any of the roles advertised to apply via www.smartrecruitment.com H. Pearson Associate.limited. See Exhibit CWM. After attending interview conducted for the recruitment approval of his appointment along with 5 others and the constitution of the new board of internal revenue by Cross River State government was contained in a letter dated 1st August 2011, reference number SSD/GSA/S/5 volume 2, duly signed by the Secretary to the State Government. See Exhibit CW1I. The Executive Governor authorized the posting of the claimant along 5 other directors as contained in letter dated 8th August 2011, reference number SSD/GSA/5 volume. See Exhibit CW1J. It is the case of the claimant that at all material times to this suit, he was under the employment of the Cross River State Civil Service and posted as Director Management Service in the Board of Inland Revenue on salary grade level 16 step 9. See Exhibit CW1A. According to the claimant, the status of employment is a statutory, permanent, and pensionable, and subject to public service rules of Cross River State. Exhibit CW1G. The claimant further stated that his employment by the Exhibit CW1A was consolidated by Exhibit DW1A, letter of appointment from Department of Establishment dated 12th of October 2011. Following dissolution of the board, sometimes in September 2013, the claimant wrote letter dated 16th day of December 2013 to the Secretary to the Government of Cross River State, requesting for redeployment in line with civil service rules of Cross River State. See Exhibit CW1H. The claimant, however, was thus dumbfounded when he discovered that his salary for the month of December was not credited to his salary account, which he thought was an error because other directors have been paid. Consequently, he wrote to the head of service via a letter dated 31st December 2023, requesting for her urgent intervention in ensuring immediate restoration of dependent salary, December salary. See Exhibit CWC. By Exhibit CW1D, the claimant had his employment with the first dependent terminated with effect from 1st December 2013. According to the claimant, Exhibit CW1D did not give him requisite notice of termination, nor was any payment made in lieu of notice thereof to him. The act of termination was illegal, irregular, and ultra-biased Cross River State Civil Service Rules, Cross River State Board of Internal Revenue Law, and Civil Service Handbook Procedure for Disciplinary Action against an officer of the civil service, and as contained in Law Number 9 of 2011, were not followed. The claimant stated that in April 2013, a panel of inquiry was set up by the first defendant against the third defendant, but the claimant was not indicted before any disciplinary committee of the Civil Service Commission or that of the board as required by Civil Service Rules 2004. The proceeding of the committee was shrouded in secrecy, and the outcome was never published in any official gazette communicated to the claimant. The claimant was shocked to find that other directors were posted to other ministries and agencies, but he was never reposted, despite his request for reposting. The claimant stated he would have been due for promotion on the 4th of September 2014 notionally to the status of a permanent secretary, which would have been attained on merit if he was still in service, in line with the rules, with the civil service rules of Cross River State. The claimant claims, as contained in his in his complaint and statement of claims have been reproduced in the earlier part of this judgment. The defendants have denied all the claims. They also stated that the claimant was not civil servant subject to Civil Service Rules 2004, as he was not qualified to be appointed into the civil service as at the time of his employment, because he was above 50 years of age, and the Public Service Rules has prohibited fresh employment to be made to persons above 45 years of age. The defendants maintained that the claimant's appointment was political, made at the pleasure of the governor. However, the claimant insisted that his appointment was not a fresh appointment because he had at one time served in the Federal Civil Service. The claimant stated that his employment has statutory labor. He cannot be disengaged without being given notice and fair hearing. The first issue to be resolved in ascertaining the status of ascertaining the status of employment of the claimant and whether Public Service Rules of Cross River State is applicable to the claimant. I must state that a person employed in the civil service whose condition of service is governed by civil service rules will be an officer of the government and has acquired a statute in employment which goes beyond that of ordinary or mere civil servant relationship. The Constitution, which in Section 197(1) established the Civil Service Commission, the second dependent in this case, and by the Section 2, subsection 1 of paragraph 2 of third schedule to the Constitution, the Commission has been closed with the power to conduct recruitment of officers into civil service. It is interesting to note that in carrying out the function of recruitment of officers into the Civil Service Commission, second dependent is not guided by the Cross River State Public, is to be guided by the Cross River State Public Service Rules 2004, made pursuant to the provisions of the Constitution. Rule 01004, sub Rule 3 and 2 of the Public Service Rules 2004 provides that civil servant and public servant should have the same meaning as assigned to them by the Constitution. By Section 318 of the Constitution as amended, it defines civil service as civil service of the state to mean service of the government of a state in civil capacity as staff of the office of the governor, deputy governor, or ministry or department of the government of the state, assigned with the responsibility for any business of government of the state. Public service of state means public service of the state means the service of the state in any capacity in respect of government of the state and includes service as clerk of the staff of House of Assembly, B, members of High Court, C, members of staff of commission authority established for the state by this Constitution or by a law of National Assembly, staff of any local government council, staff of any statutory corporation established by law of a House of Assembly, staff of any educational institution established or financial principally by the government of the state, staff of any company, enterprises in which the government of the state, its agency, control the largest share. It is clear from the above sections of the Constitution, the definition, it is very clear that whereas the operative words in the definition of civil service of the Federation, civil service of the state, are service in civil capacity of staff. The one in public service of the state are service in any capacity. In any capacity in respect of government of the state. This means that the provisions of Public Service Rules 2004 and those of Constitution have clearly shown that the term civil service of the state is narrower than the public service of the state. Indeed, the definition of public service as provided in the Constitution include the civil service of the state, while the civil service while it is not every public servant that is a civil servant. This is very clear from the two definitions given in the Constitution quoted above. See also, clearly the two words sees clearly the two terms, civil service and the public service, do not mean the same thing. Before proceeding to determine whether the claimant is employee of the second dependent or not, it is apt to consider the provisions of the Revenue Administration Law of number 9, 2011, which by Section 1 established the Cross River State Board of Internal Revenue, where the agency where the claimant served as director and board member. By virtue of Section 3, subsection 1D of the Revenue Administration Law, and by virtue of Section 3, subsection 2, the power to appoint members of the said board is vested solely on the Cross River State Governor, subject to the approval of the State House Assembly, while by virtue of Section 42A and B, Revenue Administration Law, the chairman and other members of the board, other than ex officio, shall hold office for a period of only 4 years, renewable for another 4 years and no more. The appointment shall be on such terms and conditions as may be specified in the letter of appointment pursuant to the provisions of Revenue Administration Law. The claimant, in attempt to prove his case, tendered in evidence Exhibit CWA and CWM. It is apparent from the exhibit tendered by the claimant that the process that led to the recruitment of the claimant to serve in the Cross River State Board of Internal Revenue was initiated as per Exhibit CW1M by a private firm called H. Pearson Associate. The claimant has stated in his pleading that in the panel that interviewed him for recruitment, the second dependent was represented. He also stated that in the pleadings, his pleading that his appointment and posting to the Internal Revenue and those of the 5 directors were approved by the executive governor of Cross River State. In support of this assertion, claimant pleaded and relied on Exhibit CWI and CWJ. The claimant, while placing reliance on Section 4, subsection 2B and 5 of the Revenue Administration and exhibit tendered by him and Exhibit DW1A tendered by the dependents, insisted that his appointment follows civil service rules and that his appointment is not political but have statutory flavor. Counsel for the defendant has argued that claimant has not qualified for appointment as permanent on permanent and pensionable post, having been above 45 years of age for such an appointment. The claimant, in response, has argued that his appointment is not fresh appointment, as he had at one time served in the Federal Civil Service. To buttress his contention, Exhibit CWE and CWMF respectively were tendered in evidence. By the position taken by the parties, in this case, the court's power of interpretation is called into action. For this court to properly determine the actual status of the claimant's employment and applicable terms and conditions of service is the intention of the lawmakers and the intention of the makers of the documents under consideration must be ascertained. in the exercise of its interpretative jurisdiction for justice according to law to be dispensed, the court must always draw inspiration from the consecrated principles, i.e., must only interpret words of a statute or constitutional provisions or document where they are as clear as crystal according to their ordinary and grammatical meanings without any coloration. It is true that the court are always enjoined in the course of interpretation of provisions to find out the intention of the legislature or makers of document, but there is no magical wand in this counseling. This is because the intention of the legislature, or put bluntly, the intention of the National Assembly at the federal level or State House of Assembly at state level, as in this case, is not to be judged by what is in the minds, but by its expression of that mind couched in the words of the statute. In interpreting constitutional provisions or statute or document, the guiding principle is that in such a duty is to read together all the related provisions of the statute or constitution or document. In other words, the provisions of statute, constitution, or document ought to be interpreted as one whole scheme. The provisions of a statute must be construed as a whole, that is not in isolation. If the true intendment of the lawmakers is to be ascertained, see Obayuana versus governor. See also SPDC versus Isaiah. In order to determine the meaning of the expression or phrase in an enactment, the basic question is what is the natural, ordinary, or grammatical meaning of the words used in the enactment in the context of statutes, and it is only when the ordinary meaning of those words lead to some result which cannot reasonably be supposed to have been the intention of the lawmakers that it becomes proper to look for some other possible meaning of the words concerned. See WIFO versus Attorney General of Benin State, see SPCG versus Isaiah Supra, see Omoy Jahe versus Umoru. It is not of the ancient cardinal. It is one of the ancient cardinal principles of interpretation, which has gained acceptance till date, that in order to ascertain intention of lawmaker, the enactment must be read as a whole. See Salami versus Chairman LEDB. See the implication of this principle requires consideration of all parts together, and not one part, and not one part only by itself. This means the whole part will be considered together. By this doctrine, a court is entitled and indeed bound when construing the terms of the statute, constitution, or document which throw light upon the intention of the legislator or makers of the document under consideration, and which may serve to show that the particular provisions ought to not to be construed as it will be in considered alone and apart from the rest of the statute, constitution, or document. It is clear from the above guiding principle of interpretation that general words and phrases, however wide in the abstract, are more or less classic, elastic, and admit of restriction or extension to suit the legislation or document being construed, where a statute or any written instrument consists of diverse parts or clauses. The court will always construe it looking at the whole of the documents, of the whole of the provisions or phrases, and also particular intention which is incompatible with the general one. The particular intention is considered an exception to the general one. See the case of Attorney General of Benin State versus Idigbe. See also Aqua Limited versus Ondo State Sport Council. Having at the back of the mind the above enunciated principles of interpretation of statute, constitution, or document, I shall consider the whole of the relevant related documents tendered in evidence in order to ascertain the real intention behind the law and the documents. It is clear to me, after having appraised the provisions of the Constitution relating to establishment of the powers of the second dependent, that the appointment, promotion of officers in the civil service of Cross River State is solely vested in the second dependent. See Section 2, Part 2 of the third schedule to the Constitution, and in exercising the power to make appointment or to exercise disciplinary control over persons in the civil service, the second dependent is not subject to the direction and control of any authority or person. See Section 202 of the Constitution as amended. The only guiding principle to exercise of the power of appointment recruitment in the Cross River State Public Service Rules 2004. See Rule 0201. See also Rule 0202. By the provision of Rule 01002, the Public Service Rules 2004 apply to all except where they conflict with specific conditions of service approved by the state government and written into the contract of employment or letters of appointment, insofar as the condition of service and any other law applicable to this staff are concerned. These rules apply only to the extent that they are consistent with the provisions of Constitution or of an act or law imposed in Cross River State. The provisions of Rule 01002 has in unambiguous term make it clear that appointment by second dependent must not be made in contradiction of the provisions of the law, and if there is such appointment, it will be declared inconsistent, null and void to the extent of its inconsistency with the law or terms of the letter of appointment. Having regard to the powers of the second dependent and the constitutional requirement for it to make this direction, to issue direction from any authority or person, can it be said that the appointment of the claimant as per Exhibit CW1A, CW1I, CW1J, and DW1A was properly done in line with the civil service rules? There is no doubt that the whole process that kick-started the processes that culminated into appointment of the claimant was not the product of the second dependent. The mere fact that the second dependent participated in the interview, which resulted in appointment of the claimant, and which CW1, as per Exhibit CW1, where the second dependent purportedly approved the appointment of the claimant, are not enough to have made the claimant's appointment under the civil service rules, when Exhibit CW1I and CW1J clearly shows that it is not the second dependent that approved the said employment of the claimant. The claimant has supported this when he averred in his pleading that the executive governor of Cross River State approved his appointment and his posting, having regard to the provisions of Section 202 of the Evidence Act. The appointment of the claimant has not been the product of initiation of the second dependent. Therefore, it was not properly made. To make matters worse, Exhibit CW1A and DW1A were made in contravention of the law. Rule 0205A which makes it a condition precedent for applicant for appointment into civil service must not be less than 18 years and not more than 45 years. The claimant has under cross-examination and in his pleading stated that he is above 51 years of age. Rule 020A, which makes it a condition precedent for applicant for appointment into civil service, must not be less than 18 years or above 45 years. The claimant has under cross-examination and in his pleading stated that he is above 50 years of age at the time of his appointment by Exhibit CWA and Exhibit DWA, respectively. The excuse given was that he had at the time served with the Federal Civil Service. Exhibit CW1E and CW1F were not enough to establish that the claimant had served in the Federal Civil Service. Even if it is true that the claimant had really served, that is not continuous, as according to him, he resigned his appointment and left and joined private sector. The purported service with the Federal Civil Service not being service of Cross River State cannot be reckoned with in terms of service in the Cross River State Civil Service. In the circumstances, having purportedly the purported service with the Federal Service not being service of Cross River State cannot be reckoned with in terms of service in the Cross River State Civil Service. In the circumstances, having purportedly served in the Federal Civil Service cannot demean the freshness of the offer of employment to permanent and pensionable posts in the civil service. Therefore, if it is my finding that as at the time the claimant presented himself for appointment, he is not eligible to be employed into the Cross River State Civil Service, the purported appointment as per Exhibit CW1A and DW1A having been made in contravention of the law is null and void and of no effect whatsoever, and is hereby nullified. I shall now consider whether claimant in view of Exhibit CW1J, CW1I, and CW1J can be said to be properly appointed as director board member of the Cross River State Internal Revenue, going by the stand taken by the claimant to the effect that his appointment as director and his posting to serve in the board as the board member as per Exhibit CW1J are two different things. In effect, the claimant is saying his appointment as a director by Exhibit CW1A and DW1A and his posting to serve as board member are two different things. That's why claimant wrote to Secretary to the government for redeployment in line with civil service. If it is true if it is true that the claimant was employed by the second dependent, then why should the claimant apply to the secretary to the state government for reposting to any other ministry? If it is true that it is the second defendant that employed the claimant, then it must be the second defendant who has the constitutional power of control over civil servant to repost the claimant and not the secretary to the state government. The claimant has, in reply to the defendant's statement of defense, maintained that he was appointed by the governor and posted by letter of 8 August reference number to the Board of Internal Revenue, but the claimant did not tender his letter of 8 August 2021. In evidence, the claimant also relied on letter of 9th day of August 2011, appointing him as a director in the State Internal Revenue Service. See paragraph 2 of reply to the statement of defense. On the defendant assertion that claimant was appointed for a fixed term of years, the claimant insisted that he was first and foremost a civil servant, but to civil service retirement age, which civil service retirement age of 60 years or 35 years pensionable service applies. See paragraph 5 of the reply to statement of defense. As pointed out earlier in this judgment by section 1, subsection 1 of revenue administration law, which establishes Cross River State Internal Revenue Board, section 3.1 has made it provision for composition of the board, and claimants fall under section 3, subsection 1D of the law, being head of Department of Management Service of the third defendant. By section 3, subsection 2, the appointment of members of the board is vested in the governor, and it was made subject to confirmation of the House of Assembly by section 4.2, subsection 7B. And the appointment of the claimant is to be for a period of 4 years, renewable for another 4 years and no more. This provision has gone to prove that the claimant is not an employee of civil servant, as claimed by him This has gone to show that the claimant is not, shows that civil service rules does not apply to the appointment of directors heading a department in the board. In the case at hand, though the claimant has asserted that his appointment has been approved, the appointment which would have been made up complete and in line with the law. In the circumstances has asserted that the appointment was approved by the governor, but there was no evidence to show that that appointment as a board member has been approved by the House of Assembly as required by the law. In the circumstances, the claimant assertion to the effect that his employment is regulated or governed by law number 9 cannot also hold water, as there is no evidence that the State House of Assembly has approved the purported appointment of the claimant. Going by section 318 on the definition of term civil servant and public servant, I have no doubt in my mind that any appointment to the board of Internal Revenue is an appointment to public service, which is not the same as appointment into civil service. Therefore, if the claimant's appointment is to be validly made, it has to be in line with the provisions of revenue administrative law and not the provision of civil service rules. The only civil servant allowed to be in the board are those enumerated in section 3, subsection 3B of the Revenue Administration 2011. And claimant does not fall within the category of those employees. Having found that ab initio there is no valid contract of employment between the claimant and the dependent, there is no basis of determining whether claimant's employment has been validly terminated or not, as per Exhibit CW1D. Consequently, all the other reliefs also collapse and are hereby and have no basis to stand, having all been dependent on the validity of the employment of the claimant. I must at this juncture say that this litigation would not have been necessary if right things have been done in carrying out the recruitment exercise for directors to serve in the Cross River State Board of Internal Revenue. The way and manner the entire process of recruitment as advertised in Exhibit CW1M was handled need much to be desired. The entire process was mishandled due to lack of appreciation of the procedure and processes of the exercise by those entrusted to conduct the exercise. This has also exposed the stark ignorance of the employees that manage the exercise. This means that the Attorney General of Cross River State has a lot of work to do in order to ensure that people charged with the responsibility or entrusted with tasks of complying with recruitment or carrying out recruitment into civil and public service of the state are those that have requisite knowledge of the tasks they are entrusted to perform, and also are those who appreciate the difference between the civil service and public service, and those that have the requisite power to make appointment into the civil service and public service. I shall say no more on this. On the whole, the claimant has willfully failed to prove entitlement to any of the reliefs being sought, as he had no valid contract appointment with the defendant. The case of the claimant's collapsed like a pack of facts, and same is hereby dismissed for lacking in merit. Judgment is entered accordingly. I make no order as to cost.
The court pleases. Thank you, my lord.
You are welcome.
Enjoy your vacation, my lord.
Thank you very much. I wish you all the best also.
Thank you, my lord.
We have listened to my Lord's rendition.
Yes.
And we thank you so much for taking time to appraise the issues raised.
Yes.
Thank you so much.
You are welcome. Yes, registrar, call the next case.
Yes, my lord. Suit number NICNCA 16-2023 between Dr. Jonah Bassi of 4 and 1, Government of Cross River State, 2, the Attorney General and Commissioner for Justice, Cross River State, 3, the Commissioner for Land and Urban Development, Cross River State. My Lord, the parties are absent.
Appearance. Appearance. Appearance, counsel.
My
Counsel
Lord,
for the claimant.
the claimant counsel was removed from the meeting because he was making noise. His background was very noisy. So he now called back that he has moved away from there. They should join him back. I've contacted Mr. Fatai. He sent me a link to send to him. I've done that, my Lord.
Okay.
Most humbly, my Lord, M.A. Nkiri, Assistant Director, appearing for all the defendants, my Lord. They hear me.
Okay. Yes, registrar.
Most humbly, my Lord.
When, yes.
M.A. Nkiri, Assistant Director.
Yes, I have
my Lord, I'm
recorded
appearing
your
for all the defendants.
I have recorded your appearance.
Thank you, my Lord.
But you have muted, you have removed your camera. You have to put your camera on. Registrar, when did you send the link to the counsel for the claimant?
My Lord, when the judgment you just ongoing.
I say how long? Is it up to 10 minutes, 30 minutes?
An hour now. I sent it to him at 10:15, and this is 11:12, almost an hour now, my Lord.
Call him and let him know that the case has been called.
Yes, my Lord.
He can join. Call him, please.
Thank you, my Lord.
My Lord, can you see me?
Yes, yes. This case is for ruling. The ruling is ready. It will be shortly read out. Yes, this is a ruling in respect of two applications, one by the claimant and the other by the defendants. The first application by the claimant is for an order is for interlocutory injunction, while that of the defendant is a preliminary objection to the jurisdiction of the court. On the 20th day of April 2023, this matter came up before the court for hearing of motion ex parte, praying for an order of interim injunction. However, after hearing the said motion ex parte, the court ordered that the defendant should be put on notice. Consequently, the case was adjourned to 28th day of April 2023 for hearing of the motion on notice. On 28th day of April 2023, when this matter came up for motion on notice for interlocutory injunction, the counsel for the defendant was not in court and there was no counter affidavit filed. The counsel for the claimant moved his motion on notice for interlocutory injunction and the case was adjourned to 25th day of May 2023 for ruling. On 25th day of May 2023, ruling of the court was not ready and by then counsel for the defendant has appeared and informed the court that they have filed notice of preliminary objection and counter affidavit to the defendant's application in support of the motion on notice for interlocutory injunction. The court informed counsel that the motion on notice for interlocutory injunction had been moved on 28th day of April 2023. The case was then adjourned to 26th day of July 2023 for hearing of the notice of preliminary objection, so that the court can deliver the rulings on the objection and ruling on the interlocutory application for injunction on the same day. On 26th day of July 2023, the preliminary objection to the jurisdiction of the court was taken by the court, and the case adjourned to today by consent of counsel for ruling to be delivered on the application for the interlocutory injunction and preliminary objection. In the motion on notice for interlocutory injunction, the claimant pressed the court for an order of interlocutory injunction restraining the defendants, whether by themselves or through their agents, servants, workmen, previous or others, howsoever called, from a victim, selling, dealing, or interfering with the possession of the property prescribed as House A1, the subject matter of this suit, in a manner inconsistent with the possession or interest of the claimant applicant, pending the hearing and determination of the suit. The grounds for the applications have been reproduced. I will skip reading them. The application is supported by 18 paragraphs, is supported by an 18 paragraph affidavit in support of the motion for interlocutory injunction. The said affidavit was sworn to by the claimant himself. A written address also accompanies the motion on notice. Open or in-bank Esquire counsel for appearing for the claimant in moving the application relied on the affidavit in support and adopted the written address as his argument. Counsel asked the court to grant the application as there is no counter affidavit to challenge it, the application for injunction. In the written address, a single issue was formulated for resolution, to wit, whether the plaintiff's applicant is entitled to the order spread in this motion pending the determination of the substantive truth. I have captured the argument of counsel on the issue. I shall skip reading that one. The preliminary objection was raised by the defendant, where it contend with that this court lacked jurisdiction to hear and determine this truth, on the ground that Section 25 portion of the Constitution as amended, this court does not have jurisdiction to hear and determine this truth. In arguing the objection, F.N. Nkiru, Learned Assistant Director, Civil Litigation, Minister of Justice, Calabar, Cross River State, adopted the written address file along with the notice of preliminary objection as his argument. In the written address, a sole issue was formulated for determination, to it whether the court has jurisdiction to hear and determine the claim of the subject matter of this case in view of the clear provisions of Section 25(4)(c) of the Constitution. I have captured the argument of counsel on the issue, so I shall skip reading the argument. I have also captured the claimant's argument in opposition, so I shall skip also reading that one. A reply on point of law was filed. I have also captured the argument on reply on points of law. I now go straight to the decision of the court. I have considered the two applications filed by counsel for the parties and all the process filed before the court. I shall start with the preliminary objection, since it borders on jurisdiction, and the law is tried whenever an issue of jurisdiction is raised, that has to be first and foremost be determined before proceeding to determine any other issue. The defendant applicant brought this application or objection to the land jurisdiction of this court. Jurisdiction is a court is the authority which a court possesses to decide matters brought before it, or to take cognizance of the matter presented to the court for determination. It is lifeline of adjudication of dispute, without which the proceeding, no matter how so well conducted, will be a nullity. See Madukolo versus Nkendelim, see National Bank of Nigeria Limited versus Shoyoye, see Achinoku versus Ishiaga, see Uti versus Onoibie, see Projessica, Enterprises Limited versus Leventis, C. Matari versus Ngaladima, C. Unwazi versus Idris, C. Abga versus Anyau, C. Skybank versus U, C. Start Oil Nigeria Limited versus Uducom Nigeria Limited. For determination of jurisdiction, the law enjoined the court in considering of whether it has jurisdiction or not to have a critical look of the originating processes filed by the claimant before the court. See Ogun Okum versus Military Administrator Osun State. The issue of jurisdiction is constitutional. Neither the parties nor the court, nor either by conduct or acquiescence or consent of counsel can confer jurisdiction on the court, which is not expressly donated by the Constitution or the statute creating the court. See Ijebu Ode local government versus Adedeji Balogun. See also Oloba versus Akereja. See Madukolo versus Inkendili. See Obiewu versus CBN. Therefore, no court exercises jurisdiction unless it is statutorily prescribed. Thus, jurisdiction of court cannot be inferred or implied, nor can it be conferred on a court by agreement between the parties. In other words, court cannot arrogate to itself in the instant case, the jurisdiction of National Industrial Code is both constitutional and statutory. Thus, neither the court nor the parties can confer jurisdiction on the court by conduct, consent, or inference. See Okulate versus Awosanya, see Obeu versus CBN, see Okezi versus Federal Attorney General, see Ukfong versus Commissioner for Finance. A critical look at the provisions of Section 254C of the Constitution as amended, Section 7 of the Industrial Code Act 2006, it will be shown that this code is indebted with jurisdiction, is imbued with jurisdiction to hear and determine all the labor employment related cases The advent of the third administration has injected a new lease of life into the National Industrial Code of Nigeria. The 1979, as altered, having established the code, conferred it with necessary jurisdiction to enable it effectively perform the duties assigned to it by the Constitution. Therefore, the jurisdiction of the court is subject matter based jurisdiction. The extent of the jurisdiction covers all matters, and labor, employment, and industrial relation matters and matters incidental to or connected with for proper appreciation. For proper appreciation, it is apt at this juncture to reproduce the provision of Section 254C1 of the Constitution. I have reproduced, so I shall skip reading it. A careful perusal of the above provisions of the Constitution will reveal that everything under Section 7 of the National Industrial Code Act has been covered by the above elaborate provisions of the Constitution as amended. Section 254C1 compass an extensive and unambiguous exclusive jurisdiction on the National Industrial Code of Nigeria. Therefore, the court is both a court of first instance and an appellate court. The jurisdiction of this court extends to all matters related to, incidental thereto, or commenced by any labor or employment dispute in effect. In effect, therefore, its exclusive jurisdiction extends to matters having a nexus inextricably linked or reasonably connected to subject matter of the court jurisdiction to ramification of labor and labor relate. In effect, therefore, its exclusive jurisdiction extends to all matters having nexus intricably linked or reasonably connected with the subject matter over which jurisdiction has been conferred by Section 250C. The jurisdiction of the court relates to all ramifications of labor and labor-related dispute in its length and breadth, insofar as it concerns labor. In view of the foregoing provisions of the Constitution, what this court is settled with respect in view of the foregoing provisions of the Constitution, what this court is saddled with the responsibility is to see whether claimant's claim comes within the purview of Section 254C of the Constitution as amended. To be able to decide issue of jurisdiction of the court, the claim of the claimant as encapsulated in the general form of complaint and statement of facts as the relevant materials to be considered. This is because generally the nature of dispute between the parties and the set of facts giving rise to such dispute should normally determine whether the court has jurisdiction on a particular matter or not. The brief facts which necessitated institution of this suit, as can be gleaned from the pleadings, are that the defendants served the claimant a 21 days notice to quit the residential accommodation allocated to him by the defendant in the course of his employment. The grounds of the claimant against the defendant is that, being a sitting occupier of the property allocated to him by the defendant as a result of his employment, he is entitled to the right of first refusal before the property in question can be sold to the public. The defendants, by filing this notice of preliminary objection, are deemed to have accepted and admitted the pleadings of the claimant. It is apt to produce the reliefs being sought by the claimant as per the complaint The dependent position is that this court is not vested with jurisdiction to determine claims of the claimant, as it does not matter that the claimant is an employee of the first defendant. The specific issue brought before this court by the claimant for determination is not just it relates to the status of the claimant as an employee of the first defendant, salary allowances, all. There is nothing in the claimant's contract of service showing that it is his right to accrue. It is also not that reliefs 1, 2, 3 are claims for declaratory orders of entitlement of the claimant to be offered the option to buy the houses in issue, and the invalidity of the sale where the claimant was not offered The reference made by the claimant to the government policy on monetization is not a law, especially in the case of the express desire by the defendant to sell the houses by the policy of first come, first serve. For claimant, Section 254C It was further argued that Section 7 of NICA has conferred on this court exclusive jurisdiction to adjudicate civil cases and matters relating to labor, industrial relation, union, industrial relation, and environment and conditions of work, health, safety, and welfare of labor, and matters incidental thereto, among others. There is nothing contained in the statement of facts prior sought by the claimant which robs the court of jurisdiction. Counsel insisted the issue before the court is denial of the claimant of a benefit due to him by virtue of his employment with the defendant. The employment relationship is still intact, has not been suspended nor terminated. A careful examination of the factual situation given rise to the claim contained in the statement of facts, the pleadings of the parties, its pleadings of the claimant, it will be correct to state that the course of action giving rise to this suit is connected or related to the conditions of service and welfare of employee. Therefore, the claim of the claimant falls squarely within the ambit of Section 254C1 of the Constitution and Section 7(1) of the National Industrial Code Act. This is because the facts in the instant case clearly shows that the claim of the claimant arose in connection with matters which touches or borders on conditions of service and welfare of employee as encapsulated in the provisions of Section 254C and Section 7(1) of the National Industrial Code Act. From the reliefs and the entire pleadings of the claimant, there is no doubt the claim before the court is within the purview of the provisions of Section 254C1A of the Constitution of the Federal Republic of Nigeria, 1999 as amended. Therefore, this court has requisite jurisdiction to entertain the claim of the claimant before the court. I find and so on. I now go to the second application, which is motion of notice for interlocutory injunction. It is clear to me that what this court is to determine is whether, in view of the facts so far disclosed in the affidavit in support, the claimant applicant has made out a case for grant of an order of interlocutory injunction. An order of interlocutory injunction is an equitable remedy issued or granted by a court at the suit of a party complainant directed to a party defendant in the action, or to a party made defendant for that purposes, forbidding the latter to do some act or to prevent his servant and agent to do some act which he is threatening or attempting to commit, or restraining him in the continuance thereof. Such an act being unjust and inequitable, injurious to the claimant, and not such an act be adequately redressed by an action in law. It is judicial process appraising the Interlocutory injunction is an injunction which a court of law grants on notice in the course of pendency of litigation and which lasts until the final determination of this or final determination or conclusion of the case. It is granted to protect the rest in dispute at a time when the true owner is said to be ascertained, pending the determination of the dispute between the parties. See Salami vs. Yahya. It is granted to prevent the continuation of an alleged wrongful act. See Inandi vs. Amadi. By an interlocutory injunction, the rest is preserved from being dissipated or frittered away until the substantive suit is decided. This means an order of interlocutory injunction guard and protect the rest during the pendency of litigation. In Akibu versus Oduton, the Supreme Court held that an interlocutory injunction is equally granted with the object of keeping matters in status quo. The question at issue between the parties pending the resolution of the issue between the parties is resolved. The reason behind interlocutory injunction is to maintain status quo, is to preserve the rest of the litigation from wasted, damage, or frittered away as a result of action. See Onyema and others versus Irewole local government. See Alon versus Dandrill Nigeria Limited and host of other cases cited there. The object of interlocutory injunction is to protect the rest against injury by violence of violation of his The object of interlocutory injunction is to protect the claimant against injury by violation of his right for which he could not be adequately compensated in damages recoverable in action if the uncertainty were resolved in favor of the trial. See Ekomot versus Uku, Ogunshola versus Usman, Attorney General Adamu versus Attorney General Nasarawa State, Lev PLC versus Major Kudumi. In an application of injunction in aid of the claimant's alleged in aid of his alleged right, the court will usually wish to consider whether the case is so dear and free from objection to equitable grounds, such that it augurs However, interlocutory injunction is not granted as a matter of course. See the Daika trade versus Omnia. The tendency is to avoid trying the same question twice and to grant injunction only in clear cases. See Down Pharmaceutical and Chemical Company Limited versus Benin Pharmaceutical and Cosmetics Limited. Generally, the most important factors that court consider is the grant of interlocutory injunction have been stated and restated by several decisions of the court. See, for example, Ovia Memorial Estate versus Attorney General The one big thing that is well settled, however, is that the grant or refusal of an interlocutory injunction is in the absolute discretion of the court, which discretion, like any other judicial discretion, must be exercised judicially and judiciously, having regard to all the facts and circumstances of each case and every case. It is already essential to remember that in an application for interlocutory injunction, a trial judge invokes his equitable jurisdiction, which requires him to exercise his discretionary power judicially and judiciously based on the facts presented by the parties before the court, before him, and not on extraneous matters. See Amateur versus ICC Limited. See Obonya versus Other Farm Nigeria Limited. See also doing Pharmaceutical and Chemical Company versus Benin Pharmaceutical Sufra. See also Nigerian Telecommunication versus ICIC Directory Publishers Limited. See Gadi versus Made. See Inandi versus Amadi. The burden of proof on an application for interlocutory is entirely on the applicant. He must discharge the burden in his affidavit. See Morofolo versus Kwara State College of Technology. This does not go well. It is in the light of the foregoing general principles that I shall consider and determine the application at hand against the background of the said general principle of law and facts of this case. From the affidavit evidence, the motion on notice for interlocutory injunction, it is apparent that the main grounds of the claimant applicant centers on alleged sale of house, i.e. the subject matter of this suit, when he is in possession of that house and was not given the right of first option or refusal to buy the said house. From the facts disclosed in the affidavit in support, it is clear to me that some of the issues for determinations in the substantive matter have been brought to limelight, and this court has a duty not to delve into the issues that must be determined at the substantive stage, at interlocutory stage. In the circumstances, this court will not be able to determine most of the issues that counsel have made submissions on, because if the court is to determine those issues, the same issues may likely come up at the substantive hearing. In the circumstances, I shall not do anything that will affect the substantive issues to be determined by this court in this suit. In the circumstances, I hereby order the parties to maintain status quo pending the hearing of the substantive suit. In view of the nature of the reliefs being sought in this suit, this is an appropriate case where accelerated hearing should be granted. Therefore, I hereby order accelerated hearing of this suit. Ruling is entered accordingly.
As the court pleases.
Let me see, it's in November.
My lord, 2 days or 3 days?
And the claimant counsel is not in court.
It's online, my lord. It's the one inside the car.
Okay. He is the one that's supposed to inform the court.
My lord, Elder Barrister Okumba, I apologize for the period connection to link up. My written appearance is for the complaint, the claimant.
Counsel, you are not clear. You are counsel.
My Lord, coming in. That coming in, Elder Barrister of Elder of Okumba, Esquire, the claimant also. I'm sorry for the belated appearance as a result in the area where I am.
Okay.
I appreciate your ruling.
It's all right. Yes, how many witnesses do you have? How many witnesses do you have? Counsel for the claimant, how many witnesses do you have?
My Lord, I have only one witness.
Yes, Inkiri, how many witnesses do you have in this matter? Unmute yourself. Inkiri, unmute yourself. No, it's not network. She muted herself. She should unmute.
Okay.
Inkiri, unmute yourself. Unmute.
Okay. I'm not.
Okay. Okay, my Lord,
Yes.
we have just one witness.
You have?
One witness, my Lord.
Okay, you have only one witness. So
Yes, my Lord.
how many days do you have? Because I want to grant accelerated. I have granted accelerated
My
hearing.
Lord.
How many days do you need?
My Lord, even if you give us 2 days to be okay.
Okay. Yes, registrar, give me
My
2
Lord,
days.
one day will be okay for us to put in our witness.
It's all right. I will give you 2 days. 1 day for you, 1 day for the defense.
Very well, my Lord.
Yes, registrar, give me dates.
14th and 15th of November, my Lord.
Is it convenient for you?
My Lord,
Yes, my Lord.
is convenient.
Okay, 14th and 15th. This case is hereby adjourned to 14th and 15th of November 2023 for hearing.
As a copy, please. I know we wish you a very successful vacation.
Thank you very much. I wish
And
you
really
also-
appreciate the rulings. You have learned so much from the rulings.
You are welcome.
My Lord,
Yes,
we appreciate.
Okay, thank you. Registrar, any other matter?
That's all, my Lord.
Okay. Then this case, let me see. Okay. Thank you very much, Counsel, for joining. We have come to the end of today's proceeding, virtual proceeding.
Thank you, my Lord.
Okay, you can end the sitting.